So welcome, everybody. Thank you for being here. My name is John Gaffney. I'm the president of the Courts Historical Society. And this is our very first event. So we're very excited to have a good turnout. We're excited to have a fantastic panel with us today. And we're hoping that this is just the beginning of many of these kinds of events where we look at the history of the court, the history of advocacy in veterans law, and some of those related issues that I don't think have gotten enough attention and actually deserve to be explored in more depth. It's still early. We're still building the organization, and we need your help. We need your input. We need your involvement. At the back of the room on your way out, or during, if you want to just get up and wander around, that's fine. There are brochures and business cards that have our membership application and a link to our website, so please feel free to pick those up. We'd love your input. You know, like I said, we're still growing, we're still young, and we still don't know quite what we're going to do with ourselves. And so it would be useful to have your ideas, your input, your stories, your connections, and I look forward to working with you all as we build this moving forward.
Yep.
I'd now like to introduce our panel. We are very lucky to have three individuals here with a lot of experience and history with Veterans Court. First up is Chief Judge Frank Nebeker, who was nominated by President George H.W. Bush to the court in 1989 and became the court's first Chief Judge. Judge Nebeker is a native of Utah, holds an associate's degree from Weber College, which is now Weber State University, a bachelor's degree in political science from the University of Utah, and a law degree from American University. While attending law school, Judge Nebeker began his public service career working as a White House correspondence secretary. After graduation, he was a trial attorney in the Internal Security Division of the Department of Justice. 2 years later, became an assistant United States attorney for the District of Columbia, and served from 1962 to 1969 as the chief of their appellate division. In 1969, he was appointed to the District of Columbia Court of Appeals, where he served until his retirement in 1987. Now, for most people, that would be a phenomenal career and solid, and that would be enough. But Judge Nebeker couldn't resist the call of public service, and so he cut his retirement short to serve as the Director of Office of Government Ethics, which I understand is now in this building.
It is.
And then when Congress created judicial review over VA decisions, he was appointed to the court and served until his second retirement until November of 2000. He's still a senior judge on our court as well as the District of Columbia Court of Appeals, and is active in the organization and presentation of educational programs for attorneys and judges throughout the country. Joe Violante recently retired after 18 years as the National Legislative Director at Disabled American Veterans. He was responsible there for DAV's legislative advocacy program, including their role in preparing the independent budget every year. Before becoming the director there, he was a legislative counsel and staff attorney from 1990 to 1997. And from 1985 to 1990, he worked as a staff attorney at the Board of Veterans Appeals. Joe served in the Marine Corps from 1969 to 1972, received his bachelor's degree from the University of New Mexico and his law degree from San Fernando Valley College of Law. And I understand you're spending your time now with your grandchildren and cheering for the Yankees and the Giants.
That's correct.
And finally, but certainly not least, Joan Moriarty is a Deputy Chief Counsel in what used to be known as Group 7, but is now the Court of Appeals for Veterans Claims Litigation Group at the Office of General Counsel. And she's been with them since March of 1990, representing the Secretary in matters before the court. Prior to that, she was in what used to be Group 2, where she worked on class action litigation, legislative initiatives, rulemaking, and the formulation of legal opinions. During her time at Group 7, she has also served on the Court's Rules Advisory Committee. And Judge Nebeker, you should know that in preparation for this, Joan told me that she has kept a copy of Miscellaneous Order 2-97, which you issued on December 15th, 1997, appointing her to the Rules Advisory Committee. So she has that in a place of honor. So prior to her time with Group 2, she received her bachelor's from Mount Holyoke College and her law degree from Western New England University School of Law. So we've got a great panel. I'd like to spend the first 40 or 45 minutes going through some questions that we've sort of discussed ahead of time, and then I'll open up for questions from the audience. But along the way, if you have a question or if you'd like to ask a follow-up, just raise your hand, and we'll take those as we go. I'm going to bring these mics just a little bit closer for everyone. So I'd like to start by asking each of you just to tell us a little bit about when or how you first became aware that the court existed or was being formed, and maybe share some of your initial impressions or memories of your involvement in how the court came into being. So, Judge Nebeker.
Well, can you hear? I'll bring it closer. I was director of OGE and received a telephone call from a headhunter at the White House, a man I've known and dealt with, he with clients and me with Uncle Sam as a client, as the director of the Office of Government Ethics. He wanted to know if I would be interested in being chief judge of a new court. I said, I don't know anything about it. Give me half a day to check into it. Well, fortunately, we had a law library. I pulled the U.S. Code and realized this was an opportunity because it's a rare occasion when a court is created, a U.S. court is created out of whole cloth with no entity. And so I said, yes, I'd like the opportunity to do that. Well, I didn't realize exactly what was in store, but I was taken around on the Hill, met Sonny Montgomery. Many of you remember him. I recall he asked if I would look at the Courts Enabling Act and see if there was anything I thought needed to be added to it or taken away from the Act. I did that and communicated with him at least a dozen minor items such as contempt power for the court, ability to administer oaths, housekeeping stuff like that. I looked at this one thing, single judge action. Wait a minute. Appellate courts are collegial courts, so they operate at least in divisions of 3. And so I included in the letter, you might consider doing away with that. Well, they adopted all the other suggestions I made, but that one they ignored. It was about 6 weeks later I called Sonny and said, do you remember that recommendation about single judges? Yes. Forget it. It's the best thing since sliced bread. And I was unable to convince, during my continuing education career with the appellate judiciary, I was unable to convince anybody to switch to single judge action, though I accused them all of participating in single judge action. Because every time you got a slam dunk, one judge wrote it, the other two went along with it. But that's, I guess, my introduction to what happened. I'll get into some of the other details later.
Thank you. Joe?
I was a staff attorney at the Board of Veterans' Appeals at the time, and there were always the rumors going around about the court and what was going on. There were several different versions of bills that were presented to Congress. One would have put the appeals in the appeals court or in the district courts. Another bill, which I thought was quite interesting, was designed to just rename the Board of Veterans' Appeals the Court of Veterans' Appeals, keep everyone else in place, and it would supposedly be independent. And then in the middle, they came together and decided on what we have now with specialty courts. And it was quite a tumultuous time there at the board because the chairman, Chairman Eaton, would continually get called across the street to the secretary's office, and one day he'd come back and say, Secretary wants us to put out more decisions because they're looking at this court and we want to make sure we have more decisions going out. Next week it was, we need to have more allowances. We need to allow more cases so that we'll get off of this court idea. And the next time it was, just put them out, let the court figure out what the issues should be and how they should be resolved. So it was quite an interesting period of time. And after the court came into existence, I changed sides and went over to DAV and learned a lot there. It's different.
At the time the legislation was being considered, I was a staff attorney at Group 2, and as Joe said, it was a very tumultuous time in VA as well. When the legislation was enacted, then VA, the Group 2 was going to be the primary point for representing the secretary before the new court. and our office was busy writing white papers and trying to figure out what areas of law the court might be interested in, whether there be a treating physician rule, how they would view credibility determinations. So there was a lot of white papers being written by Randy Campbell and then Drew Mullen, who both since retired from VA. When it came time to set up our shop, we took attorneys from Group 2 and moved us to an old weather building. It was on the corner of 21st and M Street, far removed from anywhere where the court was. I was involved in class action litigation at the time we started staffing up the group and couldn't go over initially. I had to wait a few months. But I was anxious to actually join be part of the new court and have a chance to create new law in a totally new area. So it was definitely an interesting time. Eventually Group 2, we couldn't stay in Group 2 because our group began growing so much, and we became known as what was known then as Group 7, and now the Court of Appeals for Veterans Claims Litigation Group.
Thanks. Chief Judge Nebeker, when you joined the court, what were your priorities coming in? Like on day one, what were the things you wanted to get done?
First thing, educate myself. As I said, I didn't know beans about it. And one of the things that happened is I talked with Howard Markey. He was then Chief Judge of the Federal Circuit. I'd met Howard on a trip to Europe that ABA sponsored, and he called me, and he said, "What's this I'm hearing about a new court? And we're going to review your decisions. How many cases can we expect?" Well, Don Ivers had been, general counsel at VA, and he had testified, I might add, against the court. And he estimated 5,000 cases would arrive in the court. Markey blanched. I know he did, even though he's on my phone. He could just see an avalanche hitting at that court. But that's proof of the fact that when the statutes were being considered, nobody filed an environmental impact statement with anybody who would be impacted with the creation of the court.
What would you say was your biggest challenge then, in those first couple days?
Oh, the biggest challenge was right after I was sworn in. I was the only judge on the court. I called a friend whom I had met, who was an assistant secretary of the Treasury. And I said, "Hey, how do I get paid?" And I had Marlene Davis with me at the time. She was the first staff employee. How does she get paid? Well, he said, "You have to get a Treasury warrant." Have you heard of a Treasury warrant? You're operating under one right now. You've got it, I hope, in a safe somewhere. But I was told I had to go down on North Capitol Street, across from Gonzaga, and pick up the Treasury warrant. And that way there would be an account with Treasury onto which we could draw. We had a very good budget to start with. I'll get to a use for that surplus budget in a minute. But Marlene got out and went into some nondescript little counter office and said she was there for a Treasury warrant. They handed it to her apparently. She brought it back in the car. And it should be in your safe. But that started the payroll. That started our ability to pay. We went for, many months before the first two associate judges were nominated and confirmed. Then we have full court capable of functioning. In the meantime, I had contacted Chief Justice Rehnquist and asked if he would be kind enough to preside over the convocation of the court. The folks in what's now the Prettyman courthouse were generous enough to say, sure, use the ceremonial courtroom on the 6th floor. So we did, and Chief Justice came down, and we had a formal convocation of the court. 3 judges were being the first panel of the court.
Thank you. Joan, sort of to follow up, you were at Group 7 in its earliest days. Can you talk a little bit about what your daily life was like as an attorney at Group 7 during those beginning days?
Certainly. It was a real learning curve. Having never had, we were starting a whole new group. We had new attorneys. Some of us had been in Group 2. We hired other people who had never been in general counsel before. We had new administrative staff who weren't used to what a court was like and what court requirements were about. And we were learning things like how to even assign cases. In getting ready for this, I found one of my earliest case lists, and this is the way they're assigned in docket order number. So that meant I got 102 cases, all in docket order number, which meant all your DORs came due at once, all your TORs came due at once, all your briefs came due at once. So we learned after that, you don't really assign cases in docket order number, and let alone 100 of them. But these were what we were faced with. Fortunately, in the early days, a lot of our cases were all jurisdictional issues, and so we were writing motions to dismiss, and they didn't all go to briefs. In fact, one of the earliest cases that I had was Magula versus Derwinski, and it turned on an M21 provision. I think it was one of the first cases the court had to address the M21, and it concerned the difference between the receipt date of an NOD and the date the NOD was recorded. And one was prior to November 18, 1988, and one was after. So the court determined the receipt date was the one they needed to look at because the recorded date was really when VA just started entering it into its system, and VA had control over that date as opposed to a date stamp receipt. So it was interesting. Some of the other logistical issues we had to face is, as I mentioned, we were on 21st and M over near Georgetown. The court was on K Street and then eventually 625 Indiana. And there's no electronic filing, so we had to get all our pleadings to the court at the end of the day. And we had an administrative assistant whose job was to load all our pleadings into his trunk and drive them over there. So that meant we were running late on our deadlines. We'd station an attorney out in front of his car, so he couldn't take off until we got the last pleading in his trunk. And he was anxious to go because he had a bowling league at night. And we had a big problem one Friday night. We got all our briefs in his trunk, and he took off. And come Monday, we found out he was late for his bowling league, so he didn't see the difference of leaving him in his trunk over the weekend and bringing him in first thing Monday morning. So he took off, went to his bowling league first thing Monday morning, brought all our pleadings in, and we had a mess. So things like that, you have to work through your learning curve, and it was interesting. Also, in the old days, we didn't know what a record was and how we were supposed to certify it. The court's rules called for us to certify the record. Which is certified. So we decided, fortunately then, the records were very small, and we hand hole punched them, and then we got blue ribbons that we put around them, and then we'd certify them with a gold seal with VA's emblem. So every single record had our little blue ribbon and gold seal, but as the records got bigger and bigger, that kind of went out the door. And in fact, we couldn't use our tool-hole punch. We had to get drills, electric drills. So every attorney knew how to work the electric drill. We had to wax sticks. You wax the drill bits, and if you don't wax them, the paper burns, and you can smell the smoke. And also, if you don't wax them, you can break the drill bit. So there was a foot press, and you make the drill go down through the paper, and that is how we drilled our holes for our TORs. I was so happy we went to electronic everything.
So it was blue tape rather than red tape in those days then?
Blue ribbon.
You started out working with your hands and not your head.
So between operating the drill and blocking people's cars, it sounded like your job was maybe a lot more physical in those days.
It was very interesting. We had a very tight-knit group because we did everything together. I mean, including typing DORs on Friday nights. That was, and we had 2 Xerox machines, so we'd have a race Saturday morning to see who could get in first to take the C file part and use the Xerox machine to copy your C file or what you needed out of the C file.
How many people were in Group 7 when it split from Group 2?
Initially, I'm not going to have a precise number, but maybe 7 or 8 of us.
Okay. It's a small group.
Yeah. And I think we had a couple legal assistants, but that grew over time.
So, Joe, you were at the board when the court was created, but you quickly moved over to the veterans side, the representation side. What role did DAV have in the early days of the court, and sort of what did you observe on the veterans bar side in terms of the early advocacy?
Well, there really wasn't much of a veterans bar at the time. DAV had a relatively large practice. I think when I came, there was a total of 6. 3 attorneys and 3 non-attorneys representing veterans. And the interesting thing was, everyone had experience in Title 38, which I think at that time was fairly rare. I think probably only Judge Ivers and Judge Steinberg had any real experience with Title 38 at the time. Everyone else was on a learning curve. The 5 years I spent at the board being immersed in Title 38 was a lot different than the first 6 months I spent at DAV learning what the law actually was. It was just a different way of doing things at the board at the time because there was no oversight, there was no judicial review. We said this cup was black, this cup was black, and there wasn't much the veteran could do about it other than ask for reconsideration, which was fairly rare. But there was just so many things wrong with what the board was doing, and it was nice to get over there to DAV representing veterans before this new court and having some type of an impression on what the court was doing. And I was fortunate because I was able to read what the VSOs presented in their arguments to the board. I was able to then use those same arguments that we ignored at the board and put before the court, and it made life a little bit easier for me.
So Joan and Joe both, can you tell us a little bit about sort of your approaches to cases early on? So writing your briefs, what did your briefs look like? What were the main kinds of arguments you presented? You're working in this area completely devoid of case law addressing Title 38. So what was your approach to dealing with that? And then once we kind of get a sense of that, Judge Nebeker, I'll ask you to give your impressions. So keep in mind that he'll be giving his honest impressions of your briefs too.
Well, first of all, just to back to my rules committee thing, I'm big into court rules. The rule required then that the briefs have cover, or if you were going to have a brief, you could have a cover. The Secretary's brief had a red cover. Helen's brief had blue cover, gray for reply briefs. And the rules also stated that you couldn't use onion skin paper unless you got permission, unless it was for international mail. And the interim rules also prohibited carbon copies being submitted to the court. And if the interim rules also stated that if a party desired to submit a printed brief, the printed matter must be on opaque, unglazed paper. It's a little different than what we do now. Back then, again, most of our issues in the really early days were jurisdictional ones. We eventually addressed issues such as treating position rule, and I had the kind of unfortunate distinction of being able to argue the Colvin case, which was obviously a land-changing case for the VA and BVA. Some facts that don't come out in the Colvin opinion were kind of interesting. It was my first oral argument. I was a baby attorney going in. I got into the courtroom. This was at Indiana Avenue at that point, and they bring Mr. Colvin in. And the attorney for Mr. Colvin introduces Mr. Colvin, who is in a high-back wheelchair, introduces his attendant, helped him get on and off the plane. And as the VA attorney, you're sitting there going, this is not going to end well. And his claim was for service connection for multiple sclerosis. When I got the board decision and I found out it was going to argument, I didn't quite know how to prepare for it because I'd read the record, and the board found, in particular, that many of his urinary symptoms were not symptomatic of MS, and the board stated these symptoms are not, burning upon urination is not symptomatic of MS, period. And I didn't know how to defend that. So one of my supervisors said, well, call the board doctor. So I picked up the phone and called Dr. Edwards, and Dr. Edwards educated me as to what urinary symptoms would be symptomatic of MS and which ones would not be. Okay, now I'm ready. So I got up before the 3 judges and started explaining explaining why burning upon urination is not symptomatic of MS, but these other urinary symptoms are, and I went into great detail, as I learned from Dr. Edwards. And I could see the judges whispering back and forth. And finally, it was clear they'd had enough, and I sat down. And the decision came out that the board needs to rely on its own medical evidence, or independent evidence. I was actually very happy that I would never have to go through that experience again. Later on, I ran into Judge Mencken, who was one of the judges on my panel, and he was over at our office for a Inns of Court meeting, and I offered him a cup of coffee. He said, "Joan, I would never take anything you offered me to drink." He said, "Do you remember that argument?" I'm like, "Yes, Your Honor." He said, "Did you see us talking?" I said, "Yes, Your Honor." He said, "Do you know what we were saying?" "No, Your Honor." He said, "We were saying, do you have to go? I have to go." That was not the argument to make in front of 3 male judges. The early days were very interesting.
Where did you go before there were 26, almost 27 volumes of the Vet App? I mean, what were your sources? I mean, obviously you had the statutes and the regulations and the M21, but in terms of case law, I mean, how did you form your arguments? We did a lot of analogies to Social Security law. We looked at, obviously, constitutional cases when you're trying to determine whether there had to be shown clear error, things like that. But again, the regulations and the manuals were a big source as well. But it was really interesting trying to write a brief with no case law. Joe, what about the flip side?
On the flip side, it was interesting because at the time I came over to DAV, they were still under the mindset that they were going to represent any case that came into them. And so we would file all of those cases as long as they weren't frivolous. In fact, my first month, I filed 30 cases, so 6 months later I had 15 briefs due at the end of January and 14 due the next week in February. But again, there was no case law. It was a clean slate that you were working with, trying to argue your interpretation of what the law meant, and as Joan said, looking at some cases out there that might have some relevance to what you were talking about. But it was a different time, and when you got those decisions, it was almost like Christmas every time you got one, because you were reading it to see what the court was saying and what you were going to be able to use or in your next argument. And it was just a different time, and I can remember some of the oral arguments. The judge I did not like to argue in front of was Chief Judge Nebeker, because he always had questions, and when he was done with the question, you always realized you were 30 to 60 degrees off from where you wanted to be, because he'd walk you down that path, and all of a sudden it was like, wait a minute, that's not what I really wanted to say. But it was different. It was unique. It was an experience probably never have the ability to experience again, because being in front of a brand new court, making the case law, helping them to interpret what we believe the law to mean, was just extremely interesting. There were also some strange things. I remember one of the staff from DAV gave me a brief that the secretary had responded to in his case, and he was claiming service connection for cluster headaches. And I'll paraphrase the brief, but basically it said, so what if the veteran had cluster headaches in service? He only recognizes migraine headaches under 8100, totally unaware of the analogous rating. So those are some of the things that you had to come back and deal with in a reply brief when General Counsel was still in the learning process, still trying to understand what all the laws and regulations were for Title 38, and coming up with some arguments like latches, which made very little sense. But so it was different. It was fun. It was exciting.
So Judge Nebeker, on the other side of the bench, you had that blank slate to write on. You're responsible for filling a good portion of the 27 volumes of the Veterans Appeals Reporter. What was it like for you? You had these arguments coming in from both sides, and you had the statutes and the regs.
Well, it wasn't a total vacuum. Let me back up. Before briefs were filed, I had asked the two judges first appointed, Farley and Kramer, would they constitute a rules committee? We had no procedural rules. We needed them, and we needed them fast. I suggested that they use FRAP, Federal Rules of Appellate Procedure, as a base for adopting our rules. They did marvelous work on it. Also, we did not have a total vacuum with respect to administrative law. There's much in the Enabling Act for judicial review that's like the APA, the Administrative Procedure Act. And we were able to have recourse to it and the provisions in our own act that were very much like the APA provisions. Judicial review, and the scope and nature of the review, and whatnot. So we started out finally getting a set of rules. I don't know that I can recall the accuracy of this. I don't know whether the FRAP rules were provided for in our statute, except, of course, we had room to amend them or modify them as we wanted. There may have been a provision. If there was, I don't remember it. But we did lean on FRAP a great deal to get the appellate process going in a knowable way for you people that were there on virgin ground and trying to figure out what in the world to do. I have to say, on reference to how many lawyers you had in the bar at that time, that Judge John Steinberg was very instrumental in what became eventually the NVLSP. He came to me and said, look, I know you got a surplus in the budget for the first year. Let's get some of that money reprogrammed. I didn't know anything about reprogramming. He did. And he was able to use staff. That was a strange thing to me. I thought Congress ran things, but staff runs an awful lot of it. And they approved reprogramming some of our money. We donated it to, what's that, Federal
Legal Services.
Legal Services Corporation. Thank you. We donated it, conscripted them, if you will, into forming an entity that would represent veterans before our court in the adversarial process. The VSOs were used to the non-adversarial process, and they felt like a square peg in a round hole, I'm sure, when it came to briefing in our court. It was a totally different role for them. But I can remember meeting with PAV, I guess, and one or two other entities, VSOs, in Roslyn, before the court was even situated. And I had, on the D.C. Court of Appeals, seen develop motions for summary affirmance. And I recognize that that's a pretty good way to get rid of the chaff, the frivolous or near frivolous appeals. And so I recommended that. Well, my two colleagues came aboard. They wanted to know, where in the hell I got the idea of summary affirmance? They were astounded at it. They wanted briefs and so forth. But it's finally shook down to where you have the central legal staff now taking those cases under their wing, identifying them, and they don't clutter the docket of the court as they would have in the beginning. I did have one experience with the Secretary's difficulty in getting records to the court. Permit just a digression. The court is very fortunate. You all know it now. You're independent in terms of budget. The Office of Budget Management, whatever it's called, OMB, can't cut the budget. It's the White House is a conduit for the court's budget, and that independence is absolutely essential to any court function. I was due to justify my budget before the Senate committee, Senator Mikulski from Maryland. And I went up early and sat in the spectator section. And she was taking the secretary over the coals. And I'm going to ask Judge Nebeker when he gets here why you and he can't sit down and get this worked out. Well, I took a note of that and waited my turn. And that's the first thing she did. She came right off that dais, wanting to know why I couldn't sit down with the secretary and get this worked out so that we get these records fast. I said, no. And, she's not used to being told no. I said, I will explain. The secretary is a party to every appeal before the court. Ethically, I cannot have an ex parte communication with one of the parties, and I won't do that. Well, I didn't mean to make you ask you to do anything unethical. Well, in the meantime, her staff was whispering in our ear, and we never heard anything about that afterward. One other thing, in its shakedown cruise, if you will, occurred when I received, and this is while we were here on New York Avenue, on Indiana Avenue. I received one of these, I guess it was a mimeograph, form letters from the House Committee. They're going to have an oversight hearing of the BVA and the court. Would I please be in attendance, etc. And I thought at the point, this is a Rubicon we better not cross. I dictated a letter, and I wish I could find it. They've hunted for it in the archives of the court. At least Marlene Davis tells me they were unable to find it. In it, I think politely, refused to subject the court to oversight. I said I'd be happy to meet informally with any member of the committee or the subcommittee to describe the work of the court and what we're doing to handle it. But oversight, no. Well, I had checked the membership of the committee, and I found that 4 or 5 of them were members of the House Judiciary Committee. And so I felt a little confident in telling them no, because at least those members of the committee would recognize they don't have oversight of federal courts. And I heard rumbles of, well, we'll just cut their pay. But we never heard another word from them. We never got another one of those oversight letters. So I'm kind of proud of that. We put a stop to it before it got away from us.
So maybe your letter is locked up with the Treasury warrant somewhere? Chief Judge Hagel, do we know where that is, by the way? I'm a little bit concerned for my own personal sake.
That's the clerk's responsibility.
Okay.
So I think the statute says he's the custodian of all the court documents.
There you go.
I can tell you I'm going back to the safe as soon as we finish.
If you find it, let me know, please.
So following up, that sort of leads me to what I'd like to talk about next, which are some of the changes that have happened to the court over the years. And Judge Nebeker, you talked a little bit about the consortium and how that came about. But I think one of the biggest changes at the court has been going from mostly pro se appellants to now, predominantly represented appellants in the proceedings today. And so I was wondering if each of you could maybe talk a little bit about the differences you saw in terms of the early days working with mostly pro se pleadings, that kind of thing, and then later on working with largely represented parties on both sides.
Well, we really had nothing to do with pro se cases because we were all representing them. But I know that watching the court decisions and the number of individuals that were filing their claim and the pro se docket increasing and the burden to put on a new court to try to understand what the law was and try to deal with a veteran who was trying to figure out what the law was. They just knew something happened to them and they wanted to be compensated. They didn't understand the law, so it was very difficult. And I can remember when the court decided to move forward with this program, and David Isabel and a group of us would go up to the Hill and talk to members of Congress, and I'll never forget one several of the meetings were on a Friday, and David showed up in his jeans, and at every meeting he announced that this is our casual Friday, and I take it seriously, and I'm in jeans, and I'm not changing for anybody. Even Arlen Specter had to back off on that one. But, yeah, it was a big problem, and something had to be done. And fortunately, the court had the foresight to, to look at this program and to get this program off the ground, because I think it's helped them immensely.
Joan, what about on the VA side? I mean, in terms of responding to informal briefs versus attorney briefs, that kind of thing, what was the biggest difference I think that you've seen, I guess, in that?
Well, clearly, as the courts, as we've gotten more and more involvement with attorneys as opposed to pro se briefs, the briefs have gotten far more complex and challenging to respond to. Also, the courts has done a lot more. I guess as attorneys have come into the practice more, it's gotten to be more complex in a number of ways. Also, the court's rules have changed, and that's changed our practice. The court has instituted a more aggressive pre-briefing conference program, and that makes us focus on the merits of the case at a very early stage, as opposed to, I think, at the beginning of our practice, we really didn't look at the merits until it was time to write the brief. And now, with the advent of the pre-briefing conference, Rule 33 conferences, I think a lot of our focus is now at the merits at a much earlier stage. So we reach agreement in I think, a good number of cases at an earlier stage, so we never reach briefing. We can do joint motions for remand. And I think the development of the joint motion for remand practice of sorts has changed the way we do litigation from the beginning, where we really didn't have that ability to do joint motions for remand at an early stage because nobody looked at the merits that early on. So I think that's been a big change. Also, the court's outreach to law schools has been a change. We didn't have arguments around the country early on, and now you have travel arguments all over the place. I mean, I've gotten to go to places such as Moscow, Idaho, Athens, Georgia. Are you? I spent a lonely 24 hours. So yeah, that's been a big change also. So just and having all the law schools involved, the outreach has been it's been an interesting change in how the court's doing business and the types of briefs we're seeing from the appellant's bar.
I'd like to follow up on that with you, Judge Nebeker. How did the outreach arguments come about? And was that during your tenure? Were you involved in the process?
Yeah, it was. We discovered it was an underwhelming reaction to having arguments at law school around, but it was brand new at the time, and I'm not sure that we put on a very good front because I'm not sure that we knew what we were doing either. But I will tell you that it became quite obvious to the court that there was a high error rate in the board. That was alluded to a little while ago. One panel doesn't follow the other. There is no drill as we have it now with appellate courts where a panel decision, when it's made, becomes binding on other members of the court at the same time. And there was a tremendous error rate. As a matter of fact, it became obvious to us under the Equal Access to Justice Act. You'll recall I wrote an opinion very early on saying the Equal Access to Justice Act did not apply to the court because waiver of sovereign immunity is very strictly construed, and the court obviously hadn't been included. It wasn't in existence when the EJA had been enacted. So having held that EJA didn't apply, the matter was taken to Federal Circuit. And the Federal Circuit, I believe, affirmed, and it was on its way to the Supreme Court when wiser heads prevailed on the Hill, and they amended EJA to include the court. That produced second highest rate. I'm not saying that they're close. There was a large gap between the avalanche of Civil Service Commission appeals in the federal district courts, which presented arguments that were not substantially justified, and thus the government had to pay the lawyers' fees. The substantial justification phenomenon appeared with the board, and VA got hooked for an awful lot of future fees. I hope that situation had changed. I know one of the reasons it did is because the board was basically reconstituted shortly after the court was formed. One, they got rid of the medical officers who were testifying, and under APA and statute, that just could not be. And so they were reformed. But in addition, I recall in the Carter administration, Carter administration, we had a general counsel of VA, a woman from Atlanta, Georgia. I forgot her name. Pardon?
Mary Lou Keener.
Mary Lou Keener.
Thank you. And she got conscripted to write what is now the precursor of the Obama Act, the healthcare law. And she was pretty well absent, but she, in her duties as regards to the VA, because Hillary had commandeered her to work that draft. Well, we became aware of that at the time that the CFR, Title 38 of CFR, didn't have any index. Well, no wonder the people with institutional memory probably remembered many of the provisions because they were dealing with them on a daily basis. The new members didn't. And I think that accounted for a tremendous lot of insubstantial positions taken at the board. And thus the cost of the Equal Access to Justice Act was really skyrocketing. I hope it's not continuing to this day.
I have a lot more questions that I could ask, but I'd like to save some time for questions and answers from the audience. But I have one last question for each of you, which is if you think back to where you were in 1990 or 1991, what about the court today would have surprised you most?
You know, I'm not sure I'm surprised. I just remember back in the early days of some of the missteps, some of the things in one case, an atomic veteran case, Combi, where the court decided that for atomic veterans, the only way that they could get service connected was to either have a radiogenic disease that was listed under the regulations for direct service connection or under presumption that none of the other laws or regs applied to atomic vets. So in other words, they couldn't come in under 3.303, I think it is, and show medical evidence of a cause and effect relationship between their exposure to ionizing radiation and their current disability. That kind of set things on their heads. Fortunately, Mr. Smith was able to get that changed in the federal circuit, and we also got Congress to look at some legislation on that. And the other one was the duty to assist. I think the court just kind of stood that issue on its head upside down and basically nullified VA's duty to assist unless the veteran already proved their case. So in the early days, there were some missteps. I have been away from the court so much now that I'm not sure what's going on, but nothing that comes to my mind that really surprises me at with the new court.
Joan?
Yeah, I agree with Joe. I don't think there's anything that really surprises me. I think it's been an interesting evolution, starting off again with no case law, and then moving on. Again, I'm partial to the rules. I think the rules have evolved over the years to really make this a thriving practice. Between now we have, again, the court conferences, I think, are a big, big change from our early practice, and I see that as a very positive thing in that it advances our analysis of the case to a much earlier stage than we had done back in the old days. And I think a lot of that results in earlier dispositions of the case and moves the cases through more quickly and gets the veteran the result that is warranted at an earlier stage. I see that as a really big change from the earlier days. Having the case law is obviously a big change, a nice thing. And now that we're moving towards we are in electronic filing, and now we're moving more towards all the electronic records. I think that's going to be very helpful. We're not lugging around huge masses of paper when you're trying to review a case. You actually can go online and review it. So that's been a nice evolution as well.
How many of you remember learning about the All Writs Act in law school? Very few. Very few. Well, somebody somewhere along the way, maybe it was me talking too, discovered the All Writs Act. And with the delay, the gargantuan delays veterans were experiencing, and I guess still are, they came up with the idea of a mandamus by the court in aid of its jurisdiction over review of board decisions in order to mandamus the secretary. The first one, as I recall, was named Erspermer or something like that. Jack Farley wrote the opinion in it, and it was obvious that the court was in a head-on collision with the secretary because there was delay and he couldn't do a thing about it. And the veterans were complaining that we should order them to do it. And we, I guess, sidestepped the issue for a number of years because we couldn't hold the secretary in contempt, and we recognized you couldn't make everybody first. And it was an impossible situation to confront at the time. I hope it's eased now, but I don't know. It's been 17 years since I was chief judge of that court. I don't know where the time went.
Well, that's all the questions I have. We have some time for some questions from the audience. Brad, if I could have you come grab one of these microphones. If you have questions, just raise your hand and Brad will come around and take your questions. So. If you could say your name first.
Yes, my name is Dan Hinson. I'm a clerk for Judge Castle on the court. My question is, I'm interested in the transition period from when the court was first established, when the board had a medical member, and sort of the sea change, and that perhaps that was part of the challenge going forward, going with the Colvin case, getting the outside medical opinion versus having a medical expert sitting there in-house, and what a sea change that was in terms of how consistent or less consistent the decisions became.
Having a medical member, in effect a witness, was obviously a due process problem of the highest order. And I think it was recognized by everyone that it really presented a records problem because the decision would be made with the testimony of the medical member. And the veteran had no opportunity to rebut or cross-examine or anything. So that was a real change in my way of thinking. And I'm sure it was to the board. When we first came out with opinions, they were not viewed by the board, I think as a whole, as precedential. Well, they just decided that one case and that's it. We don't have to follow it. Well, I think the court soon disabused that viewpoint. And now we have had, as the common law developed centuries ago, decisions that form a basis of case law, common law to an extent, if you will, for veterans' adjudications. But originally it was met with stark opposition.
One sort of follow-up is now the fact that the people sitting in judgment of the cases at the board level, that they have less medical expertise. Does that possibly raise different concerns. So yes, now we don't have the due process violation with the medical expert sort of giving testimony without having a means to rebut, but now the lack of institutional knowledge of medical expertise, does that sometimes hamstring board decisions and complicate appeals there too?
Isn't that a problem with the regional offices? Because that's where they have the examinations, and they need to know who the experts are in VA in regard to medical problems.
I don't think of it as a personal problem. I'm seeing the change in it and what it means practically, that there's less of a backstop for, say, bad doctoring at the RO level, and that could have been caught at the board level with more medical expertise. That's the only advantage I see of having a medical expert on the board.
You know, I'm on both sides of that fence because I was at the board when they had the medical doctors in the sections that dealt with medical issues, and Dr. Edwards was the doctor in my section, an expert in neurological problems, MS. So I could go to him and talk about those issues. But on the other side, I also was concerned when Charlie Cragen tried to bring the doctors back as advisors and to render opinions, because you have no control over that. And so I think it cuts both ways, but I think it's best that they're not there.
Any other questions?
Picking up on something Judge Nebeker just said about the VA and the board in particular not initially accepting that our decisions were precedential. Joe, maybe when you were still at the board, like what was the scuttlebutt? Like, what did you guys think that these meant? And Joan, did you all have any role in disseminating information into the agency?
I mean, I was at the board BC, basically before the board, before Charlie and Cragen, but there were only, I think, two cases that came out, and one was Earth Spammer, and another one that were procedural, so really there was no impact. But I do know from my experience, when the courts rendered a decision, we as a staff would brief it, get the information out to the field, get them a copy of the decision. They would take it to the rating board and be told, no, we can't consider that because we haven't heard from central office yet. So it was very frustrating in that respect that here we had law telling them, you know, what was right and what was wrong, and they refused to acknowledge it until something came out. And usually there was a long delay between when anything came out to them and when they started putting it in place. So a lot of veterans lost out on those decisions.
I know that Group 7 had very close ties with the board. There were board people who would get every decision the court had issued, and also our general counsel met regularly with the board. So I know the decisions got disseminated. I mean, I was a staff attorney then. I was not involved in that, but the decisions definitely got disseminated, and we recognized the precedential value of them at the time.
I wonder if both Joe and Joan, you could comment on the triangular relationship between the board, the secretary, and the board, the secretary, and I guess the regional offices about who represented whom.
Well, from my experience, and when I traveled around the country with DAV, talking to, VBA personnel out in the field, their impression of the court and the board, they always felt that the board was wrong, and of course the court was even more wrong than the board. But I mean, it was just a strange relationship because VBA. There are many times when I was told as a staff attorney, just send this back to the regional office, let them correct their mistake. And it was like, but isn't that what we're here for? So it was very disjointed, and I can't speak for the board at the time because, like I said, there weren't decisions coming out of the court before I left, but going back and realizing the relationship between, as I mentioned earlier, secretary would call the chairman of the board over and dictate to him what needed to be done at the board. So you had this relationship that it wasn't always holy, and it was a problem, and everyone always pointed to someone else. BBA pointed to the board pointed to the court. So it was very problematic from my experiences.
I think as an attorney for the General Counsel's office, our mission has always been to represent the Secretary, who is the nation's advocate for veterans. And our office is always very mindful of the sacrifices veterans have made and their families have made. So our perspective isn't to defend everything at all costs. Our perspective is to ensure that the veterans get the benefits to which they're entitled. Our office is also charged with protecting the public fist, so we have to balance that as well. We're not there to defend the board decisions. We are there to give an honest evaluation of the veteran's case in representing the Secretary. I think over the years we've developed, we've sought our program people's advice and consulted with them more and more. So we brought the regional office, the people in central office who then disseminate information to the regional office into our litigation discussions more than we used to in the early days. And we certainly have a close working relationship with the board. So I don't see it as any kind of a head-to-head relationship, but rather as a collaborative one to ensure that we defend the decisions that should be defended and remand the ones or settle the ones that aren't defensible.
Let me end my comments on a brief historical note. You might wonder, how come the reports of the court are handled in the regular reporting system? West Publishing was the original founder of the reporting system. During the years before, while I was on the D.C. court, I became active with an appellate judges conference seminar series, continuing legal education for appellate judges. We became, those of us who were helping to run the program, became keenly aware of the influence a man named Dwight Opperman had on the development of West Publishing Company. When the court was created, I had had a very successful relationship with him and his staff in Minnesota, in Minneapolis, in St. Paul, I guess. And I called Dwight and asked him if he would look into whether he would be willing to create a vet app report. He enthusiastically accepted. And that is the reason that we have vet app today. West carried it forward. The successors in corporate America of West Publishing Company continue to do so. I think it's a real public service. And it makes it, I'm sure, much easier to communicate to the regional offices if they have West subscriptions to what the decisions are without running them through another reproduction machine at VA. But anyway, you can thank Dwight Opperman for having been willing to expand West Publishing Company to include the court, as he had done in 1951 when COMA was created.
I think we have time for one more question. Greg?
Thank you. This is Greg Block, the clerk of the court. I should say the questions immediately before mine came from Chief Judge Hagel and Judge Sholin. Judge Nebeker, you talked about the warrant that allowed people to be paid, and I've had a chance to become very familiar with a lot of the complex relationships that allow the court to function today with the Department of Agriculture and Commerce, for example. And I wondered, you mentioned there was no antecedent court, how exciting this would be. And, you know, I wonder what the courthouse will look like. They'll call me when the first case has to be held, was maybe a thought you might have had. And when did it dawn on you that nobody was going to get paid? You had no real estate. As you and I have talked about before, you went in the back room and decided you need to order staples, pens, and pencils, for God's sake. So you were going to be stuck with all the background work before you could have this great convocation.
I became very aware of it almost instantaneously. I had indelicately put it this way. I was in charge of toilet paper and a room to use it in.
helping hands.
Well, thank you very much. Please join me in thanking our panelists for their participation today. Thank you.